Welcome to the Notes to My Legal Self AI Insights, where law and AI collide. Get ready to level up your legal game with us. We've got career advice, cutting edge developments, mind blowing legal tech, and more. Know someone making waves in the legal AI world? Nominate them, or even nominate yourself. We love courageous souls. And don't forget, we want to hear from you too. Ask questions, drop comments. Let's build a community of legal superheroes. But here's the deal. We're all about to have a blast. AI may be serious, but we're here to make it fun. So buckle up, get ready to power up, and let's embark on this exciting journey together. Now, let's introduce your fearless host, Olga Mack. Get ready to dive into the awesomeness of Notes to My Legal Self AI Insights. Let's go.
Well, hello everyone. Welcome to Notes to My Legal Self. I am really excited to have this conversation, and hopefully this time we're not going to have technical difficulties. I have exactly the same guest, and we are here to promote our book. We're still on the virtual road show, and we're going to talk about this and so much more. And God help us to have no technology issues. Jeff, welcome to the show. I am super excited that I can hear you, man.
Yes,
Please.
thank you for having me. And I don't want to blame the AI for my technical difficulties last time because my IT people have assured me it was my fault. But thank you for having me back.
But the question is, are you or are you not a bot?
Yeah. I'm the real deal. I'm the real deal. A bot would be prettier, I think. So
I don't think so. Jeff, please introduce yourself. Let's do it again.
thanks so much. So I'm Jeff Cunningham, a member at McAngus, Goodalock and Curry, and I am the law firm general counsel. I represent solo to mid-sized law firms as their outside general counsel, focusing on risk management and ethics.
And before you decided to do this, how did that happen to you?
Yeah,
What was
so
the
I
scenic route?
I came out of law school in 2010 and the job market was tough. I got a job, luckily, at Wilson Elser and was handed off to my mentor, Tom Highland, who I went to a military college and he was a Vietnam vet. So they stuck us together and we worked really well together. He defended lawyers and he was the firm's general counsel. And that's what I've done ever since. And learning from big law office of the general counsel and translating that to smaller firms has really been the focus of my practice ever since then.
He sounds like a very inspiring man.
Very, very much. Yes.
I
Yes.
love that. And I want to ask you again about that apple that you have, because that has been part of discussions
Yep.
behind your back and now in front of your face, because it's very fascinating. Tell us more about the apple.
Yeah. So the Apple logo stems from my blog is point one, a bite of ethics a day keeps legal malpractice claims away, no guarantees. And so the idea is kind of like an apple a day keeps the doctor away. But I'm also a huge, long suffering Mets fan and live in the New York City area. So it ties into the Mets and New York as well, the Big Apple. So it's all sort of connected. But I took the color, and sort of ran with the red color from the apple as well. So it's become sort of my trademark.
I love that. I mean, just so you know, I call you the apple guy.
Yeah, the emoji next to the name is very memorable. So people always remember it.
Honestly, it's your face, but the apple will do too. You have a few fans in the house. You have Sheila saying hello and sharing some things about, a black t-shirt with a bright yellow wording that said, "I'm here because you broke it." I love that.
Yeah.
We have John in the house, and he has a few things to say. Hello, John. And then we have a few folks as well here saying hello. So fantastic. Thank you so much for contributing to this treatise. I love the subject. Yeah, cheers to that. I love what you wrote about. Tell us a little bit more, and what's the takeaway?
Yeah. So, I wrote about retention, document retention, and I find that law firms tend to hold on to documents way, way too long. So having a system where you can destroy everything that you should and preserve everything that you need to is really the key. And especially for small firms, there's usually not a written policy. Usually there's some policy, but I think it's really important to have a sit down with the stakeholders and decide, what are we required to do by law or by industry standards? What are we going to do for our clients? And then how are we going to dispose of everything else? And really coming up with a plan. It doesn't have to be a complicated plan. but less is more. And also, we live in the age of AI and data, and if something needs to be recovered, it can be for a price. No matter how well you try to destroy it, it's almost always recoverable. So I think lawyers our nature is to sort of hoard information, collect as much information as we can, and I think having a policy in place to limit the amount of data that we hoard is really, really key. And you can't lose it if you don't have it. So the very first step, and I think the biggest takeaway, is really thinking about what data you need and what data you're taking that you don't need. If you don't need social security numbers, don't collect social security numbers. If you don't need birthdays, whatever it is, if you don't have the data, you can't lose the data. And I think that's the biggest first step.
I love that. I'm not sure if we're hoarders. I think because I'm reflecting on why I keep a lot of notes and sketches. I mean, it feels like handcrafted creations. I mean, who throws that away?
Yeah.
Even if I digitally create it, I put a lot of thoughts and arranging and put it together. So it does feel like taking something away from me. I reflected back on the notes I had all the way actually to high school, but I'll just say college. And my mother, who was trying to throw stuff away, and I was holding on. She said, "Have you ever looked at them?" And I said, "No, but it gives me peace to know that they're there for me." And
Yeah.
she said, "Well, it'll give you peace that they will be recycled and reincarnated into something else."
Some other notes. Yeah. No, it is. It's really an interesting problem that law firms have, and I liken it to my personal phone with pictures of my children. There's more pictures of my kids in any day of their life than pictures of me. Period. I mean, I have like 60,000 pictures and videos, and I'm never going to delete it. I have it backed up on the cloud. I have it on an external hard drive. It's a ton of data, and they're only 7 and 5. And what's going to become of that data? Who's going to want? They're not going to want to look at those pictures. And I think law firms are very much the same way. We tend to think, oh, I might use that motion 10 years down the road, or what if this client says something else happened 6 years down the road? I'll have these documents available. And I mean, there is that factor. You could always use the documents later, but for every one document that you're going to use later for some reason, there's thousands that you're not going to use. And if you're recycling old work, which everybody does, everybody uses some old document some deal that was similar, some pleading that was similar, whatever it is, you run a risk that someone uses that document and doesn't check the case law or doesn't check, updates of some kind, and that there's problems there. So, I think the net is that having a strong retention policy and getting rid of stuff you really, really don't need to save is a net positive.
Sheila has a lot of agreement with you. I'm thinking whether or not I should admit to the fact that I have a lot of videos and and pictures. My husband sat me down and asked me why we keep increasing digital storage payments. That was a very interesting conversation, very much like the conversation I had with my mother, except this was digital. And
Right.
with my husband, and he was not nearly as understanding as she. He did not tell me about reincarnation. He just told me we should decrease the recurring bill.
Yeah.
Okay.
Yeah.
So, all right. Let's talk about AI uses in the law firm, and what do we see in the wild? How
Yep.
do law firms use it today? And then let's go straight into ethical issues.
So there's really 3 ways that law firms are using it. There's law firms that are embracing it. There's law firms that are sort of looking the other way, and then there's law firms that are attempting to ban it. And when we say it, I think that's the best word for AI, because even law firms that are embracing AI, don't always define it in a way that makes any sense. And I find that the law firms that ban AI are banning it in a just a silly way. AI is in a Google algorithm. AI is in autocorrect. AI is in so much of what we use. It's in Lexis, it's in Westlaw. It's part of so much of what we use that it's such a broad category. E-discovery platforms, almost every e-discovery platform now has AI. So, to ban it is kind of silly. And it also escapes the reality that your people are still going to be using it, no matter what sort of ban you put into place. It's a sort of an unenforceable ban. I think law firms do it for that plausible deniability, so that when a lawyer goes and uses it improperly, the firm can try to turn around and say, well, we banned it, so they couldn't use it. And I don't think that's going to hold up. And I also don't think I don't think it's best practice. There's law firms that are really embracing it, and they're generally speaking, I think they're just the more tech savvy firms, or their practice areas are AI adjacent, if not really core AI use. And I think they tend to be doing a great job of it. They're really tapped into the tech and into the AI industry. And then there's most of the firms are in the middle. Most firms haven't said, no, we're going to ban whatever it is. We're going to ban it. Most firms are sort of leaving it to individual lawyers, which I think is really the right approach. I think having a written AI policy, whether you're a solo or at a 1,000 lawyer firm, having a written policy that provides a nice framework, resources, obligations for training and supervision, I think that's very, very important. But ultimately deferring to the individual professional, lawyers or non, to use the tools appropriately, I think is really the best approach that a law firm of any size can do. And then I think, having the written AI policy, really prompting your people, your lawyers and your support to figure out how they can best use AI and what your firm can do to support them in implementing AI, I think is the right approach. It sort of preempts education. It's the first step.
So let's talk. I've thought a lot about AI policies for law firms in the context of a lot at MIT project we did and the roadshow we took and conversations we've had. And it's a little dated because a few months in the age of AI where things are going at a light speed.
Hourly.
If we're talking about hours, we're hours behind, like really, really behind. And you're describing exactly the conversations we've had. There's a spread, from ban to whatever. And I really do wonder how can you possibly ban? I mean, it's like banning internet. It's not
Right.
really all that possible. It's like banning electricity. I'm being facetious, but like only so slightly.
Yeah.
But what should be in the policy? Because that's actually a debate. How much should you disclose to a client?
Yeah.
Do you have to get permission? Is that lawyer's discretion to supervise and use tools, or do you have to tell your client? Like, how do
Yeah.
you like all of that stuff that goes into policy?
So the policy, I think, there's some of the key points are really defining what you're talking about when you say AI, and that client disclosure, and then ethics generally. And I think that ethics and client disclosure sort of blend together in a lot of ways. I have AI use input into my engagement agreement. I like to have it front and center with clients that I use it, but I also have things like I use email, I use cloud technology, just to let the client know from the outset that is something I'm
Wait,
going
do
to
you
be
actually
doing.
disclose cloud
Yeah,
and email?
I have like an 18-page engagement agreement. I'm the law firm general counsel, so I
Okay,
have to have a robust.
Jeff, do you disclose electricity too?
Yes, and I also use candlelight. I let them know that
I'm
too.
not judging. It's okay. My people use candles sometimes too. It's all
Yeah,
good.
yep.
Uh,
Um, but I think it's important to let the client know you're going to use AI, and I think most clients want to see that. They want to know that you're at the forefront and you're using tools that make you efficient and effective. And I think most of our clients are using AI in some capacity. So letting the client know, whether or not you have to sort of gets into a factual analysis. If you're going to be putting the client's confidential information or even proprietary information, if it's just something that is the property of the client, if you're going to be plugging that into something that stores the data or learns from the data, then yeah, you need disclosure. In the same way that if you're using the client's confidential information with a third party expert or something, that you'll need the client on board with that approach as well. If it's their confidential information or their proprietary information, you need to have their consent. And I think having that at the outset, having that conversation right away, that you use AI and you use it for these reasons, I think clients are going to be on board with that approach. I think the confidentiality piece, lots of lawyers are really aware of that. And I think the proprietary information, safeguarding client property, I think is less on the radar of lawyers and bar associations, but equally important, maybe more important, because that's really where the value is. Client confidential information, of course, that's our that's our realm, and that's what we think of, and that's what we consider valuable. But at the end of the day, attorney-client privileged information doesn't usually have the dollar value that real proprietary information or social security numbers and dates of birth and things like that. Those actually have a dollar value. And so I think it's important to remember that we have to safeguard property just as much as confidential information.
so basically, proving damages will be easy.
Right. It sets up, it sets up the dollar damages in a way that, the confidence is may not. They could.
Yeah, yeah, interesting. Do you think this 18-page, I'm still processing the 18-page disclosure. I am a very active member of the bar. I'm really not practicing for now. I highly unlikely that I would run my own law firm, but if I were, I'm sort of asking, would I have an 18-page disclosure? And I'm hesitating because it seems like a wrong answer, but I probably
Yeah.
won't.
So my
So tell
clients,
me, is this let me phrase the question because I do have a question. There is a question there. The question is, do you think this is a point in time practice, or do you think that will go away, or this 18-page? But I worry about when law firm general counsel on air tells about the 18-page disclosure. That makes me nervous, even
yeah,
when I'm not practicing. So, Jeff, please
yeah.
tell me if I were to return to practice of law, the 18-page disclosure is not going to be my reality, or will it?
Yeah. Yeah. No, I don't think it should be. My clients are typically lawyers and law firms. And so they are not often phased by a robust engagement agreement. I recommend 3 to 5 pages. And if you are going over that, which I'm a big fan of going over that, I like to just reference the terms and conditions, something that's available on your website that has more of the general contract clauses, choice of law, entire agreement, no modification, the things that would be in any contract. I like to stick those in the terms and conditions. And then you can keep your engagement agreement focused on really the scope of services, the fees, and any conflict provisions. And I mean, the size of mine is really because of two things. One, we have a very, very well, three things. We have a robust ADR provision. We have advanced conflicts and a lot of conflicts waiver language baked right into our initial engagement agreement. And then in New York, we have to attach the client bill of rights, which is 5 pages or so. So, I mean, and that's something from the courts. So that builds out my engagement agreement quite a bit.
So not only do you come with a full disclosure, you come with a treatise.
Yes, yes, yes. So, but I like the terms and conditions. I think that makes it cleaner, a little easier for a non-lawyer client to wrap their head around, and it stays focused on the scope, which is absolutely key for both the client and the lawyer.
So let's talk about sort of the categories of AI related ethical issues. What
Mhm.
do you see in the wild as a law firm general counsel? What is it categorically? What are the things you see, and like actually, what would really help if you were to rank them from sort of the likely and worst case scenario to sort of less likely, and you can deal with that.
Yeah. So, framing it with the rules is sort of how I think about legal ethics. And rule 1.1, incompetence. And, the news has been rife with lawyers who are incompetently using AI. For every lawyer that's using, ChatGPT and thinking, Michael Cohen of Trump fame, he described Bard as a supercharged search engine. For every lawyer, he's not a lawyer anymore, but for every lawyer that's misusing AI, there's 1,000 or 10,000 who are using it really well for the tool that it is. And I think 1.1 not only demands that we actually use the AI appropriately and understand what it is and isn't, and we make sure we're not using fake case law and things like that. But I think maybe not today, but by this time next year, Rule 1.1 is really going to demand that lawyers understand how to use AI, and they are using AI. I think it's such a game changer that it will be just like someone who's like, nah, I don't email. Are there lawyers out there who don't email? Yeah, there are. Is it 100? I don't think so. I mean, it's pretty rare. So I think 1.1 is really going to be the big rule. 1.4 in communication, I think, is the other big rule. And we're starting to see more and more law firms use chatbots that use AI to initiate client intake. I think this is wonderful. I think there's going to be some growing pains. I think it's important that the client and prospective client understand that, they're not necessarily talking to a person. And I think then the ABA has put out an opinion about using non-lawyers at intake and how a lawyer has to be available. I think it's sort of setting up for an opinion about the use of AI at intake. But as long as a lawyer is available to then take over at any point when the prospect says, I don't want to talk to a robot, I want to talk to a lawyer. As long as they have that option, I think it can be done really well. Again, considering that confidential information and client property is properly protected.
So that's interesting. So 1.1, the competence part, I think what you implied is that at some point, not even using AI would actually be considered incompetent. Is that
Right.
kind of where you going
Yeah.
with it?
Yeah, I definitely think so, and I liken it to someone who doesn't use Lexis or Westlaw or any electronic research tools. So a lawyer who goes to the law library and uses the pocket parts to find case law, is that competent? I don't know if it is anymore. Maybe, but probably not. Someone who doesn't use email, doesn't use e-filing, could they be competent? Sure. Is that a big question mark? Is that a big yellow flag? I think it is. And I think by this time next year, someone who is like, no, we've banned AI, we don't use AI at all, I think that's going to be a yellow flag as well, because it doesn't make any sense. I mean, it's such a powerful tool, it's such a pervasive tool, and it's already creeping into every aspect of the law. I think in a year's time, it's going to be just table stakes, something you have to be able to use and use properly.
Yeah, it seems like it would be acceptable in very narrow communities that do
Right.
not use technologies. I think that would. I'm not saying they don't exist, and they're
Right.
certainly part of our reality. They're just a very narrow sleeve of the population.
Yeah.
And
Yeah.
so, you mentioned chatbots and as they being increasingly um, prevalent in legal practice. There's obviously some issues whether a lawyer is available, who is making decision, how much you're automating. If you're a law firm, say small to medium, and then I will talk about medium to large, what is the things that you should be exploring? What are the lowest hanging fruits of incorporating AI in your legal practice?
Yeah. So, and this is something I get asked all the time. And I think it comes down to price, and then it comes down to your clients, what your clients will value the most. Co-Counsel and Lexis Plus are really excellent research tools. If anybody out there hasn't demoed them, check them out. They're really, really impressive. And, unlike ChatGPT and Bard, they don't make up case law. They link to actual case law. And they can give you some really great work product as a nice starting point instantaneously, in under a minute. And I liken it to the work of like a first year associate. But it's instant. I mean, it really is fast, and that's for kind of substantive work. If you're looking, and I think that's great, and you should have your lawyers, be demoing those things and checking them out. They're a little expensive, but I think sort of back office roles, AI is really, really going to be a game changer for, especially for the smaller firms. I think in a lot of ways it's going to be like the Colt pistol, the great equalizer. It makes everybody the same size, and I think small firms are going to be able to use AI, leverage it to compete with a thousand lawyer firm in a way that they just couldn't before. And I think looking at what AI can do for your marketing, with content creation, analyzing, what the industry is doing. It's really able to do some really amazing stuff, and that stays pretty far away from the rules, provided you have a lawyer putting eyes on the marketing to make sure you comply with Rule 7. The billing side of it, the analysis side, like, a lot of paralegal work. If you have paralegals who summarize depositions or medical records or things like that, there's already programs that are really doing great stuff with real-time summarizing of documents, of testimony. It's really amazing. And, I don't think, and I think most people have gotten over this idea that the robots are going to replace us or replace any of us, lawyers or not. I think all it's going to do is make, the paralegal who used to do your, say, deposition summaries, it's going to allow that person to do the next level work. While the robot does the deposition summary, that paralegal is going to be able to take the summary and then start, doing analyses and evaluations that, you really do still need a person for. Maybe one day you won't.
Yeah, you have a few folks here. You have folks asking for your information. I'll let you get in touch with them. You have folks who like that you come with apples and treatise, and I think that's good. And then, of course, I do want to talk about the paralegals. I've seen a couple of great tools. I advise a couple of startups in that area related to sort of summarizing timeline creation and in litigation, really mind blowing things that are possible. And I've seen them in action, kind of how they change the course of history during the litigation. So super exciting. And you see them specialize in personal injury and employment and various other things. And I agree with you. It does, because before you're sort of competing with a big law firm, when it comes to number of bodies,
Hmm.
or, how many folks have a pulse on your team, so to speak. But now you can have a small army that has a large presence because you are able to leverage technology and you're able to get insights that you weren't able to do before. But, it also means, as Sheila pointed out, that, the concern that paralegals have been doing a lot of that work,
Hmm.
summarizing, putting it together, fetching various things. I mean, when I was doing depositions and writing briefs and preparing for my arguments, I had a small, not so small army of paralegals and
Mhm.
other professionals to help me. So help me understand where we're going with that.
Yeah. So I liken it 100% to the first industry-wide use of AI, and that was e-discovery with predictive coding. I mean, it was about 10 years ago that it started to hit the legal industry mainstream, and the objections were the exact same thing. It's going to take our jobs. It's going to take our billable hours. It's going to put all these paralegals out of business. We won't need associates. And the opposite happened, right? Predictive coding, it just made e-discovery even more effective. And it made somehow, it's just the way the law works, it made more work for the paralegals, more work for the associates. It made more billable hours by being more efficient. And I think AI is going to do the exact same thing on a broader scale than just e-discovery. We're going to get efficiency across the board. It's going to elevate everyone's practice on both sides of the V or both sides of the transaction. So I think the work's going to be there. I think as AI becomes mainstream, and this taps right into Rule 5.1 to 5.3, the supervisory rules, I think there's a real opportunity for paralegals. In my experience, lawyers are not great with tech, and we push tech down. And junior lawyers and paralegals are the ones who have to learn how to do this stuff because the older guys, and I'm starting to get there, don't want to and feel like they don't have to. I don't think that's the best practice, but it's the reality. It's what happens. And I think a sharp paralegal can really, really score some points by just hopping on and demo co-counsel, reach out. They'll give you a demo it, then go to your supervisor and say, hey, this is a really, really interesting tool. We should consider how to use this, or whatever your role is. If you're doing deposition summaries, check out some of the programs that are available, demo those, go to your, partner and say, look, we have this tool and I know how to use it. And I think it would make us really effective. And so I think there's a real opportunity. Will some people be left in the dust? Yes, I think so. Will some lawyers be left in the dust? Certainly. And a lot of lawyers, I'm ambitious that this will happen next year. The law embraces tech slowly. Like e-discovery took 20 years probably until I think we finally accepted it's a thing as a profession. And there's still a lot of lawyers who don't use it. So 20 years from now, there might be lawyers who don't use AI, but I think they'll be in the extreme minority.
Yeah, sharp anybody who uses the right tools, no matter what their title, can rule the world. That's my experience, and I think you have a lot of agreement and support. Sheila loves it and is late. Sorry, Sheila. And then you have Amber who is loving the conversation. I'm loving the conversation too. I want to shift to courts. I was recently at a dinner with judges and local judges in the county outside of the one where I live. Let's just leave it that way. I had a fantastic conversation about various forces that holding courts back. For example, court reporters. We're still manually typing things. We are trying to tie it to constitutional right, but in the end, we're doing it manually. And you have various technology from AI to actual recording, not a new technology at all that could substitute that. So you have a lot of forces that hold the court back from kind of embracing the digital transformation due to unionization, laws, practices, whatever. And then, of course, you have budgetary concerns, and then you have fears and all kinds of other stuff. So let's talk about the courts
Yeah.
because it's fantastic to talk about the justice, but
Yeah.
of course, I need to be part of it.
Yeah. And, so I practice primarily in New York City, and the Southern District, the federal court in New York, has really come down with 4 rather heavy handed, I think, opinions for lawyers misusing AI. So I think on a substantive level, the courts are very skeptical, and I think appropriately so. The bar associations, like the New York bar, has just come out with guidance. So the bar associations, I think, are trying to grapple with it as well. And the New York guidelines that just came out are really, really good. I think I was very impressed. But when you get down to the logistical level, before COVID, New York state courts, at least in the city, fax was the way we communicated with the courts. Now, once COVID hit, they moved to email and they've embraced Teams, and it really dragged the court system in New York City out of the 90s and sort of thrust it into the 2020s. I expect the courts will be slow with AI. I think we're still going to have human court reporters. As you pointed out, we could hit record in 1980, right? You didn't actually need someone sitting in the room typing up in shorthand while we all ask questions and answers. A tape recorder could have done it. There's
I mean,
something,
I feel very special when that happens.
right?
Whatever need for attention I have in life, it's totally satisfied by somebody manually recording every word I utter.
Yeah, and there's something there's gravity, right, to having an actual human court reporter there who then signs, and affirms that that's a true and accurate copy of what happened. A tape recorder is in many ways perfect, right? It records exactly what's said. A human typing is not, but there is still that there's something special about that I don't think AI is going to
I
replace.
mean, I can tell you what's special. The cost is very special.
Right? Yes,
I
yeah,
mean, if
yeah,
you talk to I've now interviewed a lot of solos and mid-sized lawyers, and they'll tell me exactly what's special about that experience. They
right.
basically pay half of their cost to that.
Yep. Yeah, and I mean, and it's something that AI can do. I mean, there's AI tools that can listen to a deposition. I mean, even Skype and Teams and Zoom can listen to the conversation and transcribe in real time. And not only can they transcribe in real time, but there's tools that can analyze in real time and sort of feed you the next questions from your outline and adapt to what the witness is saying. I mean, so I think the AI is here and it's going to permeate the courts. I think the courts are probably going to be slower on the whole. And I think there is going to be an element of protectionism, which I think we're going to have in law firms as well. I don't think anybody wants to see paralegals cut loose because we don't need paralegals anymore. I think it's just going to be a little bit of growing pains while we figure out how court reporters, how paralegals, associates, everybody, how we work with these new tools. In the same way that, when Westlaw came out, and I wasn't around when Westlaw came out, but when Westlaw came out, it was something that, big law was able to afford and small law wasn't, and the court systems weren't. And now, just the reality is that everybody has access to Westlaw, Lexis. There's a price, there's a cost, but it's not one it's not prohibitive, and it's not limited to just, the white shoe law firms out there. I think the AI platforms will be very similar as they gain momentum.
Yeah, it's interesting. I'm actually with you with respect to paralegals, associates, lawyers having other ways to contribute. I like to point out that email, as exciting as it is, has not reduced my communications that I
Yep.
receive. In
Yep.
the United States, I still cannot opt out from receiving stuff from U.S. Postal Office. I have to receive it. There's no opt-in and there's
Yep.
no opt-out. But not just that. I mean, not only do I continue receiving stuff in paper, but also the amount of communications that I receive electronically in every form from 5
Yep.
different emails and various messengers is mind-blowing. We have this technology that streamlined communication, but certainly has not reduced it. I expect essentially a parallel story with AI and every other technology. So I'm not worried about
Yep.
folks not having jobs, provided that they are able and willing and excited to learn new skills. That, of course, is a big caveat. And I think that's, everybody wants to see change, but not everyone wants to change. Actually, nobody wants to change.
Right. Yeah.
So
Yeah.
that's what we're dealing with. But with respect to courts, I was recently, I had Judge Legger on my show. He is very concerned about deep fakes.
Mm-hmm.
And, we did a very deep dive into rule of evidence and all kinds of stuff, and how courts, frankly, no one is equipped to identify fakes, and how, especially when you make decisions like TROs, where you don't have a great evidentiary hearing, or you don't have time, you make an expedited decision, you have a deep fake that could be the recording could be a really legitimate great evidence to give a TRO to take away your child, your gun, your pet, whatever.
Yeah.
And that could be life altering for many. So what are your thoughts on deep fakes?
Yeah, so that technology it's wild, and I'm not sure if you saw, but I think probably a month and a half ago at this point, a financial analyst in Hong Kong transferred like 30 million from a deep fake Teams call he had with his CFO, his direct supervisor, and other people on his team, and he had a video chat he thought with his team, and he was the only person actually on the call. The rest of the team was all deep faked. Even in, in their houses, he saw their backgrounds, and I don't know if like pets were involved or what, but it was so convincing that he actually transferred the money, and then a week later checked in, and it was revealed that it was a big elaborate scam. And so, I think, and the technology is really at its infancy, so it's only going to get better and better. I think in a lot of ways it's going to be the same as, the forged signature. And I'm sure when we first came up with signatures, people had that same concern, like, how am I going to know it's a real signature and not a fake signature? And what did we do? We developed the notary, right? And the notary stamp is going to let everybody know that, this was actually signed before the notary who obtained proof. And I think there are already ways that we can sort of authenticate a deep fake video or audio or things like that. But I think there's going to be serious growing pains with the courts, as you pointed out, on emergency basis, saying, I saw the video and it looked like this person was dangerous. So yeah, I authorized the restraining order. I think just like you'd need to have a paper document authenticated at this point to get relief from the court, I think we're going to see that more and more. In a time when we didn't used to have to authenticate videos on an emergency basis. Obviously you did for trial. I think we're going to see more and more of that, like a heightened standard, to use potentially fake material. And it'll be interesting to see. It's scary to think what scammers will do with the technology. As as the law grapples with it, the bad actors seem to embrace it at a whole different speed than our profession does.
Yeah, I mean, of course, the big difference between the deep fakes and the forged signature is scale.
Right.
You forging one signature at a time with an artist doing the thing, right?
Yeah.
Not impossible, just like very time consuming. So, like, how much can you get away with? You know, not that much. Once, twice, thrice,
Yeah.
But at scale is different, and actually, it doesn't take very long to fool somebody. I was once at a company where somebody basically was texting one of my employees, actually sounding like me. It threw the text and inspired this person to go purchase the cards at 6 o'clock in the morning,
Right.
gift cards, and
Yep. Yep.
finally at the register, he finally decided to actually slack me, and he said, "I still can't believe that you are making me do this." I happened to be up at the time, and I was like, "No, I didn't do anything. I don't know what you're talking about."
Yeah. I mean,
So, and this
yeah.
was not a deep fake. This was just somebody
A scam. Yeah.
who can see me on social media and basically write a few ways I speak and convince somebody after they stole a phone that this is
Yep.
Olga. And so
So
people are easily fooled. You
yeah.
don't need a deep fake.
And when you add that emergency component, it gets people. But if you haven't done this, I'm sure you have enough content out there. Like, I can go to ChatGPT and say, hey, pretend you're Jeff Cunningham, the law firm general counsel from LinkedIn, and write an article about X. And it does a pretty good job, I think, of mimicking my voice and my style and sort of my approach. And you should try it with yourself. Pretend you're Olga and write about this.
Jeff, I'm not disclosing everything I do with ChatGPT, but yes, absolutely.
Yeah.
I'm fairly sophisticated in the way I use it, and I
It's
actually
wild,
I
isn't it?
run all my content for consistency. I actually fed it, and for consistency, because I've been now writing for 15 years, so there's a lot
Mhm.
of content, and I'd like to check whether I contradict myself and I also measure sentiment of how I evolve, because I tend to write about things I care about. So I like to see how I progressed as human. So
Very
I
cool.
measure Olga in every way.
Yeah.
So I have a very intimate
Perfect.
relationship with that. And it's really interesting. And if you actually kind of program it, it actually can do an increasingly good job, not just like one off. If you systematically do this, it will point out to you that you're growing, evolving, regressing. It's actually quite cool.
Mhm. Wow. Yeah. That's very, very cool.
Yeah. We're coming to the end. I have a few more questions, maybe like one or two more.
Yeah.
I do want to, you alluded that we as lawyers will be embracing AI, because not doing it is going to be basically like using a typewriter or dictating your emails or not using emails in about, you said a year, 3 seconds, I don't know, 5 years. Give it a generous timeline. But
Yeah.
I think I am with you. It's imminent. paint the future. How do you think lawyers will embrace AI, and what effect do you think it will have on their lives?
Yeah, so I think it's going to really change every aspect of the law. I think the core role we have as problem solvers for our clients, whether that's in court or at the transaction table or elsewhere, I think that core is going to stay there. It's going to make us much more efficient. And I think the biggest victim of AI is not going to be paralegals. It's not going to be court reporters. It's not going to be junior attorneys. I think it's going to be the billable hour. I think our industry is very much designed towards I spent X time, I get Y dollars. And I think AI is going to really gut that because you're not going to spend the time. You're not going to be able to justify spending the time that you did before. It's going to make us much more efficient. So either our rates are going to have to skyrocket because what used to take us 10 hours takes us a half an hour and you still need the same dollar amount, or it's going to push big law, and big law being the white shoe side and also just the numbers side of law firms towards a value-based model. And I think value-based billing is going to have to grow out of incorporated AI use. Day to day, I think lawyers are going to use it. I think all of us, lawyers or not, are going to use it in a way that we take for granted, just like we have all of the internet, all of human knowledge on our phones. I think it's almost too big for us to wrap our heads around. And I think AI is going to be the same way. I think it's going to be in every conversation we have, in every phone call, whatever that looks like, we make all of our work product. I think it's going to be ubiquitous. It's going to be everywhere. And that's why I really think there's not going to be a typewriter option. There's not going to be someone or some firm that says, no, we've banned AI. It's not going to be possible.
There will be no typewriter option. I love that. I mean, that's a great takeaway.
We still had one at my old firm. I don't know that anyone ever used it, but I remember we had one. So yeah.
I was, I go antiquing sometimes, and I was tempted to buy one.
Oh, that's gonna be cool. Yeah.
Yeah, my daughter was rolling my eyes. I was about to overcome it. My second daughter walked in, and she's like, "You're not going to," and roll her eyes. And I was still determined. And then my mother walked in with my husband, and both of them collectively. So we walked away. We walked away from the typewriter. But I had some nostalgia. Yeah. Okay. We've come to the end. This has been a fantastic conversation. We've covered a lot of ground. I mean, from apples to ethics to typewriters. This was a lot. Jeff, what is the one takeaway you want folks to take from this conversation?
Yeah, so thank you so much for having me. It has been a great conversation, and I really appreciate you bringing me back on after my technical problems. Again, I'm not blaming the robots. I think the one takeaway is really to figure out where you can sort of, with the least amount of investment, the least amount of pain, incorporate AI into your practice, whether that's substantively doing legal work, whether it's back office stuff, marketing, whatever. Just one area where you can start to get ahead of it, and one area where you can add value to your clients.
I love this. This is such a great conversation. I'm so glad we were able to overcome our technical issues and fly again. Thank you so much for being on the show. You had a lot of fans in the audience cheering for you, asking for more questions. So I'll let you go answer whatever we.
I'll over there and answer away. Thank you so much.
You bet. Thank you so much, everyone, for joining. Thank you for giving us a second chance at this conversation. I'll see you next time. Bye.
And that brings us to the end of another thrilling episode on the Notes to My Legal Self AI Insights. We had a fantastic time exploring the fascinating intersection of law and AI with you. But hold on tight, because the adventure doesn't stop here. Stay connected with us on social media to continue the conversation, share your thoughts, and be part of our incredible community of legal enthusiasts. Together, we can inspire, learn, and make a real impact on the world of law and AI. If you enjoyed today's episode, we encourage you to share it with your friends, colleagues, and anyone else who could benefit from the exciting insights we discussed. Let's spread the knowledge and enthusiasm far and wide.